Hello everyone, welcome back to LaExcellence Bengaluru presents current issue of the day, episode number 164. Today we'll be discussing a topic which is going to be very important and very relevant for upcoming mains, that is judicial pendency. The topic reads: Justice delayed, democracy derailed. India's mounting judicial backlog. So this is a topic which is going to be very significant from the upcoming mains exam. So in this topic I have covered it holistically. First we will see why it is in news and what is judicial pendency, what are the reasons and what are its implications, and also with a special emphasis to alternate dispute resolution mechanisms as well as lok adalats, and also we will see policy way forward to address this issue. So we will be covering in a holistic way so that you can make a structured mains answer. Now moving to syllabus, it comes under GS paper 2 polity. Within that, judiciary, governance and ADR mechanisms. And why is it in context? Recently Draupadi Murmu remarked India's judiciary as a black coat syndrome. Why? She said that because India is facing a serious justice delivery crisis with over 5 crore pending cases in the judiciary across various courts. Amid this, mechanisms like alternate dispute resolutions and lok adalats have gained relevance, having resolved 27.5 crore cases between 21-25. In just over 5 years, lok adalats were able to solve 27.5 crore cases. So at one end the judiciary is failing miserably, at other end the alternative dispute resolutions are acting as a shining light. So we will see the implications, the reasons and other things. So why is of swift justice very important? Why is timely justice important? Because it maintains rule of law. That is, swift justice reinforces people's faith in institutions, that is government institutions, in this case judiciary. An example for you: in Jessica Lal case there was a judicial delay. Initial delays led to public outrage and later fast-tracked appeal restored credibility. When there was a delay and it resulted in public outrage, only then it has to be fast-tracked. So whenever there is fast-track justice, it restores credibility and it brings public trust and it reduces trust deficit among the citizenry and the governance. Next is, it deters crime. That is, fast track courts post Nirbhaya case increase legal deterrence. Next is, it reduces victim trauma. They say that justice delayed is justice denied. So longer the justice is delayed, longer will be the justice denied. So the people or the victims who are the sufferers of grave crimes are going to be under a serious trauma. That is what? Delays extend emotional stress. It increases emotional stress and also results in PTSD, that is post-traumatic stress disorder. Example, the 2002 Gujarat riots, slow trials prolonged victim suffering. This can be the case with respect to many. Same thing happened with respect to Kashmir exodus. During the Kashmir exodus, the victims are demanding justice for almost 25 years now and still they are not able to get the justice. That is the case. And then it prevents misuse. How? Delays enable tampering of evidence and threats. Example, post Bhopal gas tragedy, 26-year delay weakened public faith. What happened in post Bhopal tragedy? The Union Carbide company, which was the reason behind the gas leakage, was able to tamper the evidence, was able to escape India with as lesser repercussions as possible. They didn't pay the compensation properly and none of the higher ups in the Union Carbide were sent to jail or subjected to prosecution. This is what happens when the justice is not swift. So we understood the significance of swift justice. Then why is there delay? What are the reasons, the causes for structural delays in the courts? First cause is the judicial vacancies. Delays in appointments have led to overburdening of serving judges. For example, as of 2024, the data is very important. Over 30% of High Court posts remain unfilled. The High Court, that is the second most important judicial court in the India after Supreme Court, those courts are suffering from vacancy of up to 30%. So that is how grave the situation is. Next is procedural inefficiencies, that is frequent adjournments, outdated rules and non-cooperative litigants cause the stagnation and increase the delay. For example, Order 17 of the CPC is misused to seek repeated adjournments. This is an order under CPC which is used by the courts. This CPC is used in order to adjourn the sessions, in order to adjourn the judgment, and as a result it keeps on prolonging the justice. Next, inadequate infrastructure. Courts, especially in smaller towns and rural areas, lack proper infrastructure and IT tools. Many district courts lack e-filing systems or video conferencing setups. Next, the government is the major litigant. That is, the government is the single largest litigant. That is, nearly 50% of the pending cases are belonging to government, and most of them are often unnecessary. Routine revenue and land disputes often clog the courts for years. What happens here is, in economy, there is a term called as crowding out. Okay, economy, there is a term called as crowding out. What is this crowding out? Whenever the government borrows from the public, in the sense the banks and financial institutions, etc., whenever the government is borrowing at a large amount, there is less amount or the less money available in the market for the private players. So this increasing government borrowing from the public is leading to the crowding out of private institutions. This phenomenon is called as crowding out. If it is reverse, that is, government is not borrowing from the public, instead it is generating its own revenue, and private are allowed to borrow from the public, it results in crowding in effect. This is the same case with respect to current judiciary as well. You can say the crowding out effect is found in even the judiciary as well. Next, who is crowded out here? The common citizenry who are in need of swift justice are being crowded out because of the governments. Next is lack of case management system. Absence of structured timelines, electronic docket systems or monitoring tools in regular courts. This is one of the major reasons as well. For example, unlike fast track courts, most trial courts lack any calendar based scheduling. There is no schedules available. As a result, they are not able to consider the cases in a timely manner. Next, there is another issue with respect to civil cases in district courts. They are the most affected. Even among the judiciary, these are the most affected. Who? The district courts, especially with respect to civil cases. Why? Because of the frequent adjournments. It is both plaintiffs and defendants sometimes exploit the provision of adjournments to delay the justice. Next, for example, these are case studies which you can quote in your answer. That is why I am covering this. For example, in Uttar Pradesh, a single party reportedly sought 20 adjournments over 5 years, pushing the matter indefinitely. This can be seen in many cases as well. Recently in Ramanagara, a case has been followed or extended for more than 20 years now. A land dispute which can be solved very easily with all the evidences present, but the litigant who is present here, or the litigant who is present here, he has been or she has been expanding the case indefinitely. Next, insufficient judicial strength at lower levels. District judiciary handles the bulk of India's litigation but remains the most neglected. For example, in Madhya Pradesh, a single district judge was dealing with over 2000 cases simultaneously, making individual attention impossible. Just imagine, a single judge is dealing with more than 2000 cases. How will we be able to give attention to single cases? Obviously, there is going to be justice delayed. Obviously, even if the justice is given, the justice won't be satisfactory. Next, delayed submissions by government agencies. In civil cases involving local bodies, delays are common due to late filing of the replies or affidavits or evidences. For example, In Maharashtra, a municipal corporation took 18 months to file a written statement in the civil suit. These are the reasons why civil cases in the district courts are the most pending ones. So these case studies which are given, the Uttar Pradesh, MP and Maharashtra, can be very helpful in your answers. So make note of these important cases. Role of alternative dispute resolution in addressing this pendency. ADR refers to methods like mediation, arbitration and reconciliation and negotiation, which helps parties settle disputes without going through long drawn formal battles. You don't have to go to the court. Instead, you can settle the issue with each other through mediation. There will be a mediator. Through conciliation, a conciliator will be provided, and arbitration, and arbitrator will be there, and negotiation between the two parties. These are alternate dispute resolutions. And what is the benefits of alternate dispute resolution? It reduces burden on the formal courts. That is, ADR routes resolve disputes in an amicable way, in a quickly preventing new cases from entering into the courts. As a result, it will reduce the burden on formal courts such as High Court, District Courts and Supreme Court. Example, Delhi's Tis Hazari Mediation Center alone has resolved 2 lakh plus cases since 2005. This is also a good example for you to quote. And faster and less expensive. Most ADR methods are faster than the formal courts, saving litigants legal cost, mental stress and also time. For example, arbitration in commercial disputes typically resolve matters within 12 to 18 months compared to civil courts which drag on it for 5 to 10 years. Okay, it is done within 1 or 1.5 years, whereas this in civil courts takes around 5 to 6 years. Confidential and flexible. That is, ADR often protects the privacy of the parties and allows customized solutions depending on the litigants, especially in family or property disputes. Okay, that is why alternate dispute resolutions have so many benefits over the formal courts. Next, the case of Lok Adalats. How effective are the Lok Adalats in clearing judicial backlog? Lok Adalats have been established under Legal Service Authorities Act of 1987. Strength is, what are the strengths, and also see the limitations. In terms of strengths, high volume disposal, efficient in disposing compoundable criminal as well as civil disputes, including check bounce, motor accident claims and matrimonial matters. These are the provisions which have been included under Legal Service Authorities Act. Example, in November 2023, National Lok Adalat, over 1 crore cases were resolved in just one day. Just one day, 1 crore cases were resolved. That is how significant or swift the justice is. Then, cost-free and speedy process. There is no court fees are required and decisions are reached quickly with a mutual agreement, and the decree or the order given by these Lok Adalats are binding in nature, and there is no appeal exists for them, and this is not appealable. Binding nature, that is, Lok Adalat decisions are final and have legal status equal to court decree. No further appeal is allowed, which ensures finality and reduces chances of relitigation. Then focus is on the pre-litigation stage. That is, they also handle disputes even before they reach litigation stage, even before they reach the court formally, thus proactively preventing case pendency from rising. So they have lots of advantages, and the strength is very high. However, there are certain limitations which needs to be addressed. The limitations such as not suited for complex legal, constitutional or serious criminal issues. This has to be taken to the court itself, that is formal courts itself. Then it requires mutual consent. So not all the disputes are easily resolved, because the bringing mutual consent is not very easy as it sounds. So it is sometimes delayed as well. However, from the strengths, it is very clear that they are a very amicable alternative solution for formal courts to reduce judicial pendency. Next, the comparison between alternate dispute resolution and Lok Adalats. In definition, ADR is an umbrella term for informal dispute resolution methods such as arbitration, mediation, negotiation and reconciliation or conciliation. Lok Adalat, it is a specific ADR method institutionalized in India. Lok Adalat is nothing but part of alternate dispute resolutions which are institutionalized under LSA Act. Next, scope is arbitration, mediation, conciliation. Here, focuses on civil and compoundable criminal matters which are provided under LSA Act. Legal status, arbitration is binding, however, negotiation and mediation or conciliation outcomes depend on the settlement. They can be appealed again. However, in Lok Adalat, awards are binding and enforceable like court degrees. Next, in appeal, arbitration awards can be challenged in limited circumstances. However, they are non-appealable. It cannot be challenged in any circumstances. In ADR, the cost and formality may involve some sort of legal fees and formal processes. However, in Lok Adalats, it is informal and cost-free. And then the nature of cases, ADR can only deal with civil, commercial and family, etc. However, in Lok Adalats, mostly compoundable criminal as well as civil disputes. So, criminal cases or compoundable criminal cases can also be dealt by Lok Adalats. Okay, next is how do you address the issue of judicial pendency? What should be the way forward along with this ADR and Lok Adalat? First and foremost is filling the vacancies. Fast track filling up the vacant spots in judiciary, high court, supreme court and all the district courts. Filling vacancies and improve district court infrastructure. Second is promote ADR through training and public awareness. Adopt e-Lok Adalats and online dispute resolutions and introduce case management tools to reduce pendency via scheduling and tracking. There should be proper scheduling, there should be proper tracking so that the cases are not pending. This way we can address the judicial pendency case. So this ends our discussion for the day. If you like the video, then please hit the like button, comment on it and also share with your friends. And if you want any new topics to be discussed which are relevant from prelims, mains or interview perspective, drop down in the comment box. I will be bringing down videos for the particular topic. And if you are new to the channel, please subscribe to the channel, click on the bell icon so that you don't miss any notification. With this, I will end the video. Jai Hind.